In this video, I will explain why everyone needs an estate plan and what is a living trust and do you need one. That is the subject of this video. Welcome to the Financial Fast Lane. My name is Lane Martinson. And so the majority of folks don't have any estate planning done. And I think there's some really understandable reasons why that's the case. Estate planning is something that it's not really a fun subject to talk about, right? It has to deal with your end-of-life stuff and not really a fun thing to talk about. It can feel intimidating, meeting with attorneys, and it's expensive and it can feel complicated. And a lot of times people feel like, well, estate planning is only for people who have a lot of assets. And that's not true. Everyone should have estate planning. And so in this video, I hope to really simplify it so that you understand the key concepts and why you should not procrastinate putting together an estate plan. I will draw an illustration on my little whiteboard here. Now, in this example, let's say that we have a married couple, husband and wife. Now, after the death of one spouse, typically, the surviving spouse owns and controls all the assets. But what happens after the death of the second spouse? Let's say that they have some assets, some property, maybe a home, right? Some real estate. And let's say that they have some family. They're beneficiaries. Now, what happens at the death of the second spouse, in this case? There's essentially a canyon that separates the beneficiaries or your family from the assets. And this canyon has a name. We call it probate. So probate is a legal process. It is judges and lawyers and the court system. And it can be very time-consuming and it can be very costly. And it can easily be avoided with a little estate planning. Assets that pass via contract will completely bypass probate, quickly and privately. A few probate examples from some famous people that you may know, like Aretha Franklin. Aretha Franklin died in 2018. Originally, her family believed that she did not have any estate planning done whatsoever. But eventually, they found two handwritten wills. One that she had in a safe, and then later they found another in her couch. It was under a sofa cushion. The two handwritten wills were different, and they left assets to different people. So the three of her four sons became divided, and estate litigation carried on for 5 years. So it ultimately came down to a Michigan jury that decided that the will under the sofa cushion represented her last wishes. So this was an incredibly time-consuming example, expensive, and no doubt, probably the worst part was the strain on family relations. I'm sure the last thing Aretha wanted was her sons to be fighting with each other over her estate. Now, this could have been easily avoided had there been some estate planning documents in place. You probably remember this guy, Sonny Bono. Sonny died in a tragic skiing accident, and he did not have a will or any estate planning documents in place. Sonny's wife, Mary Bono, became the estate's administrator, and she started the probate process. Then, ex-wife, Cher, and her attorneys wanted $1.5 million of Sonny's estate for past alimony and child support that she said he never paid. And then there was a 30-year-old man that showed up and says that his mom and Sonny had a relationship 30 years ago, and that he was Sonny's natural-born son, and that he felt that he deserved some of the estate. So we know all of this because probate courts are public information. So privacy is another reason for estate planning. Now, this case with Sonny Bono took about 3 years to finalize. Again, expensive, time-consuming, and embarrassing for the family. Prince is another high-profile case where there were no estate planning documents in place. This was an especially expensive case with legal fees in the tens of millions. After 6 years of probate, this case is just now starting to wind down. Having a will is definitely better than not having a will, but a will does not avoid probate. A will simply lets the judge know your wishes. Having a will guarantee that your estate will go through the probate process. Avoiding probate is a simple thing to do with a little estate planning. Any asset that passes via contract will avoid probate. An example of a contract that would pass an asset is a simple beneficiary designation. When you first establish a retirement account, such as a 401k or an IRA, designating a beneficiary is a required step. But other accounts, such as brokerage accounts, bank accounts, do not ask for a beneficiary designation. However, you can designate beneficiaries on all of those types of accounts, but it's just not automatic. For investment accounts, they are referred to as TOD, or transfer on death form, that you would complete. For bank accounts, it's referred to as a POD, or a payable on death form, but they're simply beneficiary designations. Beneficiary designations are an important part of an estate plan, but they are rarely sufficient. A living trust can simplify everything and make it a lot easier to manage. So what is a living trust? It is a legal document that creates a new legal entity, an entity that you own and control while you're living. You can move assets in and out of the trust at any time. You specify what happens to the trust, the assets after you die. A revocable living trust is revocable, which means that you can make changes at any time while you're living. After you pass, or after the second spouse passes, then the trust becomes irrevocable. At that point, meaning that no one else can make any changes, and only your wishes, as you had indicated, will be carried out. So now what about real estate? In most states, the only way to avoid probate with your real estate is with a trust. There are a handful of states that allow for a beneficiary deed. This is a legal document that essentially designates a beneficiary on a piece of real estate, which will avoid probate. But there are advantages to using a trust to manage all of your assets. Probate avoidance is only one part of estate planning, as important as that is. You will also really want to make sure that you have other vital documents for planning for incapacity and other related issues. You probably remember Terri Schiavo. Terri was only in her 30s when she had a cardiac arrest. She survived physically, but due to the lack of oxygen to her brain, she suffered severe brain damage. She was in a permanent vegetative state, kept alive with feeding tubes. The doctor says she will never recover. Now, Terri did not have any estate planning documents in place. So after a year or so, Terri's husband said, "Look, I know Terri, and she would not want to be kept alive artificially and at great cost, with no chance of recovery." But Terri's parents disagreed, and there became a bitter wedge between Terri's husband and her parents. And I'm sure that that is not something that Terri wanted to happen. Terri laid in that bed on life support for 15 years before the appeals process finally resulted in a court order that ended the life support, and Terri died in 2005. Now think of the impact that this had on Terri's family. Think of how this changed the life of her husband and her parents, and the tremendous cost over 15 years. All of that could have been easily avoided with a simple document called a living will. A living will is something that everyone should have. In this case, who do you think should have made the decision? The husband, the parents, the children, if there were children? The answer is none of them, right? Terri is the one that should have made the decision when she was well. And the way you do that is with a living will and an estate plan. I know this is not fun stuff to think about, but you should consider the impact of leaving difficult decisions to your loved ones. Other essential documents that everyone should have would include a durable power of attorney. This authorizes someone that you name to manage your financial matters if you're in a coma or unable to make decisions. Similar, a healthcare power of attorney, another document that everyone should have. So what are your options for getting all this done? You can find a qualified estate planning firm in your local area. That may be the best choice, but it will also be the most expensive choice, typically costing between $3,000 to $5,000 in attorney's fees. There are documents you can get online for much less, but that can be a huge mistake, and we do not recommend doing it yourself. You really want to make sure that you get this right. Now, we have a complete will and trust package that is both affordable and complete. It includes all of the necessary documents listed on the screen, and it is considered a complete estate planning package. The cost is just $600, and it is available in all 50 states. Now, I am a financial planner and an investment advisor. I am not an attorney. The documents are prepared and drafted by estate planning attorneys, and my staff provide guidance through the process. And then we help you with knowing how to properly archive and to fund the trust, as well as to provide guidance on appropriate beneficiary designations. I always say estate planning is an act of love for your family. Being prepared and having your ducks in a row will be a great blessing to them. It is the responsible thing to do. You don't want to feel intimidated by the process. You just want to bite the bullet and get it done. And then you can have the peace of mind that comes with being prepared. Remember, everyone has an estate plan. It's either the government's default version and the court system, or it's your own private plan that you have put into place. I look forward to seeing you in the next episode of the Financial Fast Lane.